This is Barry Zalma speaking for Claim School Incorporated. Today I'd like to speak about bad faith, tort, and damages. In 1958, the California Supreme Court, with the best of intentions, changed centuries of contract law in a case called Comunale versus Traders and General Insurance Company, a California Supreme Court decision rendered on July 22, 1958, and made an insurer's breach of contract under particularly egregious circumstances a tort and allowed damages more than those allowed under contract common law, finding that there is an implied covenant of good faith and fair dealing in every contract, that neither party will do anything which will injure the right of the other to receive the benefits of the agreement. The court concluded that the principle was applicable to policies of insurance. The implied obligation of good faith and fair dealing requires the insurer to settle in an appropriate case, even if the express terms of the policy do not impose such a duty. The Comunales were treated badly. The insurer failed to consider the interests of its insureds, and by so doing, by failing to accept a reasonable settlement offer, violated the duty of good faith owed to the Comunales and allowed them for the first time in a breach of an insurance contract case to recover tort damages. The tort of bad faith, created without precedent out of the good intentions of the court, was expanded as time went by, and insurers were found to be liable for various types of tort damages, including punitive damages designed to punish and deter wrongful conduct. The first cases finding a tort of bad faith dealt with third-party liability policies until 1972, when the California Supreme Court decided Grunberg versus Aetna Insurance Company. This case, rendered on the year I first became a member of the California Bar, applied the tort of bad faith to first-party property claims. State legislatures have enacted unfair claims settlement acts to legislate what the Comunale and Grunberg courts created. Those who have adopted all parts or expanded upon the National Association of Insurance Commissioners' Model Unfair Claims Settlement Practices statute include courts from Alaska, Arizona, Arkansas, California, Colorado, Connecticut, Delaware, Florida, Georgia, Hawaii, Idaho, Illinois, Indiana, Kansas, Kentucky, Louisiana, and many, many more states, all the way down in alphabetical order to Vermont and Wyoming. The tort was adopted by almost every state of the United States, either by court decision, legislation, or both, and the business of insurance and insurance claims handling was never the same again. Punitive damages were assessed against insurance companies in gigantic amounts, with juries and courts awarding punitive damages more than 100 times greater than the amount of compensatory damages for breach of an insurance contract. After a few decades of abuse of the tort of bad faith by insureds and plaintiffs or policyholder lawyers, recognizing the impact of the law of unintended consequences, the U.S. Supreme Court in State Farm Mutual versus Campbell, a 2003 decision, found it inappropriate to assess punitive damages for more than 10 times compensatory damages, and that in most cases punitive damages should never be more than 1 time the compensatory damages. The National Association of Insurance Commissioners also created an unfair property casualty claim settlement practices model regulation that has been adopted in whole or in part or has expanded upon the regulation of almost every state in the Union, and at least Florida, Kansas, Kentucky, Missouri, Nebraska, Nevada, New Jersey, New York, Ohio, Oklahoma, Oregon, Pennsylvania, Rhode Island, Utah, Vermont, Virginia, Washington, and West Virginia. In addition, California and other states have created their own set of unfair claim settlement practices regulations. Whether state-created or based on the NAIC model regulation, the state's regulations result in the micromanaging of claims handling and set minimum standards of claims handling that plaintiffs can use to create a bad faith presumption if the insurer did not meet those minimum standards. The regulations do not deal with the fact that almost every insurance claim is unique and is like a square peg trying to fit into the round hole created by the regulations. Since all insurance claims are unique, the claims handling of an individual claim may not fit within the requirements of the Fair Claims Settlement Practices regulations or statutes. Plaintiffs' lawyers invariably seek tort and punitive damages because of the claimed failure to fulfill the minimum standards. The bad faith suits thereafter attempt to hold insurers hostage when a claim is rejected, even if the rejection was proper and in accordance with the terms and conditions of the policy. The attempt to help consumers get their claims paid promptly was another victim of the law of unintended consequences and resulted in encouraging litigation rather than the fair settlement of claims, providing the insured the benefits promised by the policy and nothing more than the benefits promised by the policy. The tort of bad faith resulted in thousands of suits seeking tort damages. Hundreds of judgments were entered against insurers for multiple millions of dollars. Thousands of suits against insurers were settled for amounts in multiples of policy limits for fear of becoming the victim of a runaway jury and punitive damages. The good deed created by the good intentions of the California Supreme Court in Cumanali and in Grunberg became a nightmare for insurers who could not convince trial judges and appellate judges that the law of unintended consequences had struck. For example, the following are just a few bad faith verdicts drawn from news reports. $568,000 paid to a woman in a case against Progressive Select Insurance. $130 million to homeowners underpaid by Farmers Insurance. $20 million civil verdict overturned because attention to anyone being defended by an insurance company for a car accident or liability claim. $13 million in insurance payouts required for dropping clients from the insurance. $233,000 for insurance bad faith estimates for a glass repair. Uninsured patients received a 35% refund for overpriced medical bills at Scripps Health hospitals. Walgreens pays undisclosed amount for dispensing wrong medicine leading to miscarriage. $1 million settlement by Allstate Insurance for failure to pay a claim. A New Jersey woman receives $50,000 verdict against Allstate. A life insurance company was hit for a $39 million judgment for failure to pay a claim. A $14 million punitive damages ordered by a jury for insurance companies' refusal to pay benefits. State Farm required $2.5 million to a couple for denying a Katrina claim. $250,000 was paid by an insurer for flooding deaths, and $20 million verdict against Allstate Insurance. Bad faith judgments, including both compensatory contract damages, tort damages, and punitive damages, continue. They are only held back slightly by the Supreme Court decision in State Farm versus Campbell. The law of unintended consequences continues to wreak havoc on the insurance industry, although recent appellate decisions have provided insurers with defenses that make it more difficult, but not impossible, for policyholders to succeed in pursuing tort and punitive damages when the insurer's decision to refuse payment was fairly debatable, or there was a reasonable, genuine dispute between the insured and the insurer. In my opinion, the tort of bad faith proves the concept that the road to hell is paved with good intentions. The cure of bad faith conduct by insurers led to an abuse of the business of insurance by fraudsters, insureds, and lawyers who got rich off tort damages, including punitive damages, that made the cost of insurance greater than it would have been had there never been a tort of bad faith. It's time to reconsider the tort. Thank you for your attention. This video was adapted from my book, It's Time to Abolish the Tort of Bad Faith, which is available as a Kindle book and a paperback from Amazon.com. If you watch this video on Rumble, please click on the Rumble button, and if you watch the video on YouTube, please click on the like button. Thank you again.